Hello, and welcome to another edition of Car Brief. I'm your host, Richard L. Slager, a licensed attorney in the state of Illinois. And I have once more dredged up another horror story brought to you from the legal graveyard of automotive terror. I bring to you the case of Montgomery versus Nostalgia Lane, Inc. This is a case that was decided on June 30th of 2008 in the state of Illinois. It's a second district case. This is not unlike the case I reported on earlier, which involved the restoration of a Pontiac Firebird. This particular case involves the restoration of a 1970 Plymouth Roadrunner. Nice car. I can understand why somebody would like to restore a car like that. This particular case, the plaintiff, Mr. Montgomery, contacted the defendant, Nostalgia Lane, Inc., to restore his 70 Roadrunner. And the defendant inspected the vehicle and indicated that they could do this project and it would be the cost of approximately $35,000, but the final bill would reflect the actual cost of parts and labor. The plaintiff agreed and the project went forward, and he was to pay installment payments of $3,500 every 2 weeks until the vehicle was restored. He continued with his payments, and that amounted to $33,500, but the defendant deviated from the estimated cost. In this particular case, this was a written estimate that was provided, unlike the Firebird case. So here we have a written estimate. It's going to cost $35,000 plus or minus. Well, you can imagine it's more likely going to be plus than minus, as is always the case with restorations or home building. They went over budget. And the plaintiff paid the defendant an outstanding balance that was owing of $5,899 to get his vehicle back, because they were holding his vehicle until he paid that extra money over and above what they had quoted him for the restoration of the vehicle. Well, the facts are as follows. The plaintiff purchased his car in 1989 and it wasn't drivable. It could not be driven. And the plaintiff initially contacted the defendant in May of 1998, so we're looking at almost 10 years since the purchase of his vehicle, so it must have sat in storage. And it was decided that he was going to go forward and get this vehicle restored. They indicated that the vehicle could be done, and the written estimate was drawn up. And the defendant estimated the cost of parts and labor to be $35,000, with a notation that all jobs will be ultimately billed as time, materials, and labor, plus the parts. Plaintiff was to make the payments, as I mentioned previously, of $3,500 every 2 weeks, and the labor costs would be $42 an hour. And that sounds probably about right for that time frame. In September of '99, the defendant took possession of the car. They started the restoration process. The plaintiff was of the opinion that he wouldn't mind. He ultimately wanted the vehicle to be drivable, but he wouldn't mind if they also made it look good as well. The agreement was at least to get it to drivable condition. That never happened. The vehicle was not drivable when ultimately the plaintiff went and picked it up. And the plaintiff was furious because the vehicle still wasn't drivable. It still had not been restored, yet he had been quoted a price of $35,000 that would or theoretically should do it. And it didn't. He ultimately brought the vehicle to another restoration shop, and they completed the restoration at considerably greater cost. I think it was around another $20,000+ to get the job done. And he sued, obviously, the first restoration shop, indicating that they overcharged him, and they also lured him into a contract by overestimating or actually underestimating the amount of the cost to actually get this vehicle restored to a decent level. And they simply didn't do that. So the plaintiff cited in his actually third amended complaint, so it must have been dismissed a few times before that. In his third amended complaint, in count one, he indicated there was a deviation from the Automotive Repair Act, which is a repair act in the state of Illinois. And there are also violations of the Consumer Fraud Act as well. So he tied those all up in count one, which isn't really good pleading. You should separate out your pleading into different counts, but they had been jumbled into one count of several other counts, but the other counts were dismissed out, and the court was left to address this one count. The trial court dismissed the count indicating that there was no genuine issue of material fact, that in fact the Automotive Repair Act had not been violated, and there was really no finding of any kind of, or no evidence, so to speak, of any kind of consumer fraud. And the plaintiff appealed, which is what brings this case in front of the appellate courts for the 2nd District in the state of Illinois. And the court in the 2nd District went on to analyze the issues and indicated that the trial court had committed reversible error in granting the defendant's summary judgment, indicating that the Automotive Repair Act did in fact apply, and also there could be questions of fact as to whether there was a deviation as to the Consumer Fraud and Protection Act that was invoked in the pleadings by the plaintiff. One thing in passing, they went into definitions of the Automotive Repair Act and looked to a dictionary to define what a motor vehicle repair facility was versus a restoration shop. They said that a restoration shop is also the same as a motor vehicle repair facility. They got into the very minutiae or small details of wording in the act itself, and the court liberally construed the act to include automotive restoration shops, to make a long story short. One thing that I found rather amusing is that the defendant made an argument, they made kind of a frivolous argument. The court notes that the defendant also takes the unseemly tack of trivializing the plaintiff's interest in his car, noting that the plaintiff had the goal of driving the Plymouth Roadrunner as a second car for fun. Defendant argues that the ordinary consumer relies upon his or her car to assist in meeting basic needs, and that it is not necessary for an ordinary consumer to have a souped-up vintage hot rod to meet the needs of his or her family. So that was their argument, and that's why they thought the Automotive Repair Act didn't apply. The defendant implied that a consumer like the plaintiff, who uses his vehicle for recreation and fun, is somehow less worthy of consumer protection than a person who uses his vehicle for basic transportation. The court goes on to note that the General Assembly never intended value judgments when it enacted the Automotive Repair Act, and we will not create an artificial distinction here. So the argument the defendant was making was a little bit ludicrous, but sometimes when you're losing a case, you're going to grasp at straws to see what you could possibly do to save it. But they realized they were losing on appeal as the argumentation goes, and this may have been set for oral argument. I don't know. It's not clear at this point. With regards to malfunctions of motor vehicles, we disagreed with the defendant's position that the services it performed did not address malfunctions of plaintiff's motor vehicles, emphasizing that a car could not be driven when the project began. The defendant echoes the trial court's distinction between malfunctioning vehicles and non-functioning vehicles, and the defendant suggested that only malfunctioning vehicles are governed by the Automotive Repair Act because Section 10 declares that an automotive repair facility and a motor vehicle repair facility engaged in the business of automotive repairs or diagnosis or both of malfunctions of motor vehicles. So they said, well, because this vehicle is non-functioning, it doesn't fall within the purview of the Automotive Repair Act. And the court said that's ridiculous. And as I mentioned earlier, the court also indicated that there was a genuine issue of material fact. And the case was reversed and remanded back to the trial court, so the plaintiff got another bite at the apple. The outcome of that, they probably settled it rather than going to trial. It's not clear at this point. Once a case gets reversed and remanded, typically you don't find the outcome. Sometimes you do if the trial court makes another mistake and then it goes up on appeal a second time, but there was no indication in the record here that that's what happened. And the court ultimately gave the plaintiff another chance. So what's the takeaway from this particular case? Well, in my earlier synopsis of the Firebird case, you really want to get something in writing. Well, now we have a case where they got something in writing, and that didn't work either, apparently, because the defendant, they did salesman's puffing and saying, oh, no problem, we can restore this car for $35,000. And of course, it went over budget. And that's always a danger when you're getting a car restored. What is the takeaway from this? Now I submit that if you're going to restore a car, make sure that the money you put into it, you're theoretically going to get out of the car, that it's a highly collectible car and it's going to be worth its value of the money that you put in for the restoration. Because if it isn't, if it's a a low value car and you put a lot more money into the restoration, you're going to lose money on the deal if you ultimately come time to sell the car. But if you do it out of a labor of love, then the money shouldn't be the object because you genuinely like the car for whatever reason. Fine, go ahead and restore it. The alternative would be to buy a car that's already been restored, let somebody else eat the cost, and you have a fun restored car that you don't have to worry about the headache of what these people did in the courts. And that would be the best advice I could give you. Buy a car that's restored, or if you're going to restore one, make sure, check the values of the car and weigh and consider the cost of the restoration versus what the cost of the car is when you purchase it, and see if that makes financial sense to you. Once again, check the laws of your local states. I practice law in Illinois, and this is not intended as a representation of giving you legal advice. So you want to check with a lawyer if you're running into any legal hardships or difficulties. Well, that case having been analyzed, now the air is clear and the rain has stopped. The clouds are gone, and we're once more returning to a sunny day with the case over. Until the legal storm clouds form once more in another case of automotive terror brought to you by the courts. I'm Richard Elslager, your host of Car Brief, and I bid you happy motoring and drive defensively. Until then, take care.